Hi, my name is Andrew Kinney. I'm an attorney at Hoglund Law Offices. I practice Social Security disability law. Today I wanted to talk about past relevant work. It's a phrase that Social Security uses a lot. What it basically means is it's work you used to do within the last 15 years. That's essentially what it is. Why is it important? Well, when Social Security makes decisions about disability insurance and supplemental security income, they go through a process. They decide first if someone's currently working. They look at what's called SGA issues. There's another video on that. Then they look to what medical problems affect work in any basic way. That's called a severity step. The third step is deciding if the individual meets or equals any sort of definition or listing of disability. The fourth step, finally, is can you return to your past relevant work, what you used to do? And they have definitions of what you used to do exactly as opposed to what you used to do as a general category. There's another step after that as to your ability to perform other work. But in terms of focusing on past relevant work, Social Security evaluates your past work in every single case. Now, the essence of past relevant work is you probably know you can't return to your past work if you're applying for benefits. The medical standard is, can you work full-time at either your past work or other work? That generally applies to most people, depending on age. So, practically speaking, most people who are considering disability benefits or have applied for Social Security disability benefits don't think they can return to their past work. Now, here's the crux of the problem. Social Security, when you're under 50, at least in terms of how the laws work now, will consider whether you can return to not just what you used to do, perhaps a specialist in something, skilled craftsman, or maybe a lawyer or whatever. Social Security will look not to just whether you can return to that job. Let's say you had a stroke and you can't concentrate too well. They'll consider for people under 50 whether they can return to other work as well. So you can benefit greatly from having some legal advice as to whether you should apply, or if you have applied, how do I meet by definition a disability? Because if the only thing you can't do is your past work, but you could probably perform some full-time work in some other capacity, your attorney is going to need to make arguments that you are by definition disability. Again, you're by definition disabled if you meet certain criteria. And again, I'll mention stroke, but it can also apply for any manner of health problems. A lot of the health problems are listed on our disability library at hoglundlaw.com. The other instance where past relevant work actually is very important, though, is if you are over 50 or within 6 months of age 50. And this can happen when you've applied, or it can happen after you have your pending appeal. In that case, Social Security looks to see if you have physical restrictions first. If physically you're limited to, let's say, sit-down work or sedentary work, and the definition of sedentary is in Social Security's regulations, as absorbed through what's called the Dictionary of Occupational Titles. Social Security looks to see if you can't return to your past work, and you're limited to sit-down work, and you're over 50, and you don't have skills that can maybe shift into some other sort of sedentary work, you can be what's called gridded out. There are some guidelines that Social Security uses for people over 50, and that's again an instance where past relevant work is crucial. So if you have questions about past relevant work, please feel free. If you don't already have an attorney, you can call our office at 1-800-850-7867. You can also go on our website at hoglundlaw.com, and hopefully this information can help you. If we can actually represent you, that's wonderful. But keep in mind that these concepts are specific to Social Security, so getting to know them is very important. Thank you.